5215 is not listed.
Yes, it's okay.
No.
What is that?
Oh, yes. Yes. Yes.
The lordships have been taken extensively through the prayers, the statute provisions. If I understand the scheme of the prayers, like the page 45, we have here a very unusual set of prayers. Ordinarily, if a statute, an action taken under the statute is illegal, then you go to the roots of the matter, take the statute, look at this, it's unconstitutional. Then come to the actions taken. If the statute is otherwise constitutional or legal, you may say the action is ultra vires of the statute. Here it's a very unusual prayer. You say, first let's find out if they can succeed on the ground of the demand from the issue of the state of Orissa will stand in terms of the rules. If I don't succeed there, then I will challenge the rule. And there I have some preliminary submission to make.
Oh.
Now, the act has been amended over a period of time, agreement and rule 20, etc. I thought if the mine development protection agreement signed by them in 2020 incorporates everything about what the statute has in mind, and the rule also being incorporated in the agreement, can you turn around and say that, look at this contract is bad? Because I'm now being asked to do something impossible. Rule 12A, if I say, before I invite Lord's attention to that, therefore, a few parts of the agreement, kindly turn to page 180 and
When this 12E was amended, when the 12E was amended,
2020
or introduced, mines and minerals.
I invite Lord's attention first to this agreement, which is
What you will find,
27th of June 2020.
what you will find is the 12B, either it was revamped or for the first time introduced with effect from I think 20th of March 2020.
Yes, yes.
And then there was an additional sub-rule 1A was introduced on 1st July 2021.
1A, 1B, 1C were introduced later. I'll look at it later.
What they were arguing was that when you say about a contract, that it really impinges upon a contract. If the contract goes, then everything, all the rights flowing from a contract will also go.
That's true.
There's no doubt about it. But what they say is that the contract was entered into at a prior time, means before that amendment came into force. Now they say that this particular provision, I would say, is arbitrary, is contrary to the main statute, is contrary to the constitutional obligations. If I correctly understood the entire gamut of argument which they were advancing was the expressions, the production and dispatch. They were really harping on that there cannot be any nexus between a production and a dispatch. One may produce as per the contract, but may not dispatch, because the dispatch depends upon the viability of the product in the market or the demand of the product in the market. So if I do not dispatch, that does not mean I have not produced. So for non-dispatch, because the market, there is a recession in the recession in the market. There is no demand. As you know, the economic
That's
very basic factor, the demand and supply.
I know.
So you know, that's why I'm just reminding. So this is what they really wanted to say, that why should I be penalized for not dispatching it? I can be penalized for non-production.
I'll address the argument. I'll exactly address the argument. Because I'm going to look at it from an entirely different point of view. The argument advanced before the court is something which is not told to us, right? Not part of our
And
understanding.
these
of what
agreements
we-
were prior to coming in force of this amendment.
Yeah. What the substratum of the argument, something which is not even addressed to us, not even brought to our notice, something which I would probably not even look at. So now you're asking me to look at it and we abide by that. So I'll try to make with a submission that if you look at the entire scheme, I have a couple of points to raise. I thought before I get into the larger canvas,
Yes, definitely.
I want to slightly preliminary point that if you enter into an agreement, minus rules 1A, 1B, 1C, etc.
Yes.
And I proceed on the footing for the time being that the entirety of Rule 12A was there when the agreement was entered into. And therefore, the agreement constitutes your entry into the mining operations.
True.
And there are a few parts of the agreement, like any contractual agreements like this. There is always a warranty that look at abide by the contents of the contract, and any amendment to the contract in terms of law will be brought from time to time. These are well settled propositions. Now we are looking at natural resources of the country. It's not any private contract or a trade for building a building or any commercial contract. So please keep in mind Article 297 of the Constitution. When the natural resources of the country are in question and understanding for the purpose of serving the larger public interest. Therefore, if 297 says, read with Article 39B, the resource of the community shall be so distributed as to serve the common good. So the basic submission going to be the entirety of mineral wealth of the country is meant to subserve the common good of the country.
True.
Therefore, whatever regulatory framework which Parliament probably would intend to bring in, and thereafter given some authority to the delegates, bring delegated legislation, would always be seen from the point of the larger public interest and subserving the common good. And therefore, it is not like any other private or a commercial contract which involves any other resource. Therefore, an important distinction is, please keep in mind Article 297 and the public interest element involving the entire mineral wealth of our country. And since we are therefore talking about that aspect of the matter, the way the court would look at a statute and the subordinate legislation always be from the point of view whether these are in tune and to realize the object and purpose of the larger public interest element. And if there is something missing, suppose the word is not able to convey the precise intent and the purpose, the court will see this is what probably the obvious meaning of the statute. In contract, law just knows an obvious bystander, oh, that's what he meant. Something which is so obvious need not be expressly stated. Therefore, if Parliament intended after 2015 to bring in an auction process and to bring the best in the market to ensure that the mineral wealth of the country is so exploited and extracted as to subserve the common good. So the guiding factor, lodestar, will be how will it subserve the common good? So every part of the MMDI Act will be therefore seen from this point of view. If you all not keep that in mind, therefore I thought when you enter into an agreement and say I'll be bound by certain provisions of this amended from time to time, can you now turn around and say, look here, I have some problem there. Now I have some problem. Because after entering into like section 56 of the Contract Act, the impossibility of performance will be entirely different footing. A building will disappear, you can't continue the building. A subsidence of a land, you can't continue to work on it. These are examples of frustration. Somebody says, I will marry you, but marry cannot take this. But it's not one such case. Therefore, the mere fact that it has become economically unviable for you, from your point of view. So could you now turn back and say, I want to challenge this rule? So I thought there is a threshold issue on that the court may have to consider. I'll go into the larger question. I thought I'll just flag it. I'll come back a little later. Broadly speaking, my submissions would run on the following lines. The challenge to Rule 12A, including the amendments brought in 2021, are premised on an unduly narrow and artificial construction of sections 5B and 8B of the Act. And if I am right in saying that Rule 12A, as inserted in 2020 and later in 2021, is in tune with and not in derogation of Section 4B, then there is no room for an argument that the Rule 12A is in conflict with Section 5, Section 18, etc., and other provisions of the Act. Then the further argument, if I am right in it, the further argument that compulsory dispatch, which comes in a later point of time, is unreasonable and manifestly arbitrary, because that's what Dr. Singh is arguing, because of being perversely disproportionate. He's misconceived. I think a person who is recipient of a grant of a mining lease subjects oneself to the scheme of the statute, the public interest underlying the scheme of the Act, and any other restriction that can be imposed as would be an achievement to the larger public interest purpose. And therefore, no person who secures a mining lease post-2020 can be heard to say that the mining operation shall not be subjected to any regulation towards securing the public interest, or the continuance of availability of mineral in order to meet the consumer interests of the country. So in the context, I think, of generally economic activity, and particularly in the domain of natural resources, Article 297, I think the state is the ultimate authority to lay down terms and conditions in the matter of engagement with the use, exploitation, extraction, trade and commerce involving natural resources. There is no room for any proportionality argument in this case. There's hardly any room for a proportionality argument in the context of economic activities where the state acts in furtherance of public interest condition. The two classes of brownfield and greenfield are based on well understood distinctions, and I'll get into a little later. Then the mining plan, on which much emphasis has been laid. The mining plan is only one chapter of the entire set of arrangements in the engagement of mining operations. It is not the only one in the conclusive chapter. So the mining plan provides for a lot of technical assistance. For instance, we go back to the early part of our country in the Mines Act, and it's all about the securing the proper protection to the workers, all those things. Now we have gone beyond that stage. We can't go back to a 18th, 19th century understanding of what mining operations in the hands of private parties. Therefore, the mining plan is only one chapter of the entire gamut of operations of mining operations. It can't be placed on a higher level than either the statute or the rules or even the agreement. Next, I think argument has been made between Section 13 and 18 of the Act. I understand, depending upon the nature of an act, the apportionment or allocation of delegated legislation can be in different ways. Therefore, 13 and 18 talk about certain common purposes. They also talk about certain other rule-making authorities. Merely because it is 13 and 18 does not mean 13 is to be seen distinct from 18 or vice versa. Both of them, I would say, constitute a collective component of delegated apportionment to delegated legislation. Therefore, whatever is found in 13 need not necessarily be seen in 18 and vice versa. And you can't have a pigeonhole. There can't be a pigeonhole that says 13 will lie here, 18 will lie here. Therefore, you can't find it in 18. It can't be found in 13. So the rule making, the delegation of power to the delegate authority will be seen from the larger point of what does the Act want to achieve. So it can therefore apportion for a certain purposes under a certain provision, for other purposes under certain other provisions. For 13 and 18, I would say constitute one composite collective set of delegation of to rule-making authority. So don't set them as pigeonholes and distinct, apportionment of power. Then I'll come to section 4B, because that way everything will depend on how do you read 4B, section 4B. If you not to kindly just allow me to come to the section itself for the time being. Now, as I said, we have moved far away from the original application scheme of the MMRDA. Prior to 2015, somebody will make an application, and depending on the application or the eligibility, etc., of the applicant, mining list used to be granted. I was told that experience of the government was that in several mining areas, you get a mining lease, you will not diligently work the mining operation to begin with, wait for some opportune moment to begin mining, and do mining in your own way. So the market probably will guide you. The experience is now how long should you wait at the mercy of the mining leaseholder when the larger national interest of mining mineral wealth should subserve the common good. This experience has therefore gone is the intent behind the enactment of Rule 4A, Section 4A, 4B, and thereafter Rule 20. Therefore, now there is a paradigm shift. The paradigm shift is how do we ensure that who gets into the mining operation will be an agent or a tool of subserving the common good of the country. If we keep that in mind, now why is that Section 4B had to be enacted? Before I come to 4A and the argument that 4A uses the word production and dispatch, 4B does not talk about it, and therefore Rule 12A cannot be probably said to be a well-articulated provision. And before I come to that, Rule of Section 4B, if I read it to my own understanding, notwithstanding anything contained in Section 4A, I'll presently explain why this non-obstante clause was necessary. I just skip it for the time being. I proceed in the footing, it is not there. The central government may, in the interest of maintaining sustained production of minerals in the country, prescribe such conditions as will be necessary for commencement and continuation of production by the holders of mining leases to acquire rights, approvals, clearances, and the like under Section 8B. In the absence of Section 8B, every person who gets a mining lease will have to get a large number of clearances and approvals. 8B has been enacted to ensure that as soon as you get a mining lease, the original clearance approvals obtaining at the earlier leaseholder will now be available to you. The amount of investment required, the time required for you to get the clearance approval is now taken care of. Therefore, immediately after you get a mining lease, you are in a position to start doing your mining operations. So if that facility has been made available in the Section 8B, now why would 4B be necessary at all? Are you to, if the larger purpose, national purpose of Article 297 and 39B should be kept in mind, then the sustained production of minerals in the country will be the most important way of looking at it. The legislature could have used any other words. You could have said all possible things about sustained production could have been put in the statute. But it does not mean that the parliamentary intent is very narrow. Parliament is only talking about production of minerals. When you use the word sustained production of minerals, you are able to produce in order that the consumer, the industrial consumers, and those who would consume the mineral will be able to get it without any disruption. That is the purpose behind the use of the word sustained production. You don't produce and store the mineral wealth at the mine pit for some storage purposes. It is not, therefore, probably if the idea, we had the good old day, the Essential Commodity Act. So hoarding was something which was prohibited in the essential commodity. You can't hoard any essential commodity. Minerals are essential commodities of the country. There may not be a separate law governing this mineral wealth as an essential commodity. The entire scheme of the MMRD Act, I think, is talking about mineral wealth and essential commodity of the country. If therefore sustained production means you produce and pass it on to the market on a sustained basis, on a continuous, non-destructible basis, Therefore, in order to achieve that, the government now said, I will probably be able to make some rules to achieve the end and purpose. So sustained production of minerals in the country in Section 4B, like for instance, we have in the context of rice. One of the earliest American cases, Griswold versus the United States, when the court said privacy was a penumbra, concept of a penumbra. So I think it's possible to look at Section 4B to say it contains and comprehends all those possible dimensions and facets of what is sustained production. Even though Parliament does not say by way of an explanatory essay what is sustained mineral production, the Parliament need not have done at all. Therefore, sustained mineral production, taking cue from the penumbra concept, it comprehends all possible dimensions and facets of mineral production, which includes dispatch and ultimate consumption. I suppose I don't produce a mineral, and then stack it, store it, and take a selfie out of it. It's not for that purpose. You must produce and make it available for the ultimate consumer. You're not producing for your own consumption, even for self-consumption, certain percentage are available. Therefore, the faceted dimension of making it available for the ultimate end user is an important component of sustained production of mineral. So sustained production of mineral comprehends within it all those penumbral areas, namely production, dispatch, in due course of time on a sustained basis. You take away all those meanings in sustained production, it becomes a bare bone without communicating in a sense whatsoever as far as 297 and the Article 13 and ideas are concerned. You don't have a bare bone in Section 4B. So therefore, Section 4B will have to be construed from having a wider import. If you consider it from that point of view, then whatever would advance the purpose of Section 4B, namely a sustained continual availability of mineral wealth for end users. So when you talk of production, the availability of mineral wealth. In the absence of availability of mineral wealth, it is, as I said, it will be an ideal activity to just produce and keep it for yourself.
Sustained productions, that also ensures the stability so far as the price is concerned.
Yes.
Otherwise, there will be a steep rise if there is a shortage.
No, I understand that. But I'm trying to build an argument saying that if Parliament...
This is what really you wanted, that the production is of a wider connotations and imbibe within itself all facets of the extraction of the natural minerals or the resources,
right,
including the sustainable supply in the market for the purpose of the consumption by the end users.
That's right.
So that also ensures the stability of the prices, the stability that the inflation, there is a steep rise because of the shortage that should not come.
Absolutely.
So that impacted many aspects because it has a larger impact on the other sectors as well.
Very true.
That is what...
Very true. Today, for instance, I give an example. We have the CCTVs. The chip which is used in the CCTVs comes from China. Now, there are a lot of idea that we now start making indigenous chips. The chip industry is like a chip war among nations today. And one of the petitioners is now setting up a factory in Andhra Pradesh for making wafers and for the solar industry. These are important, essential minerals that must get into the market and the industry. And how do you ensure they get in the market and the industry for appropriate consumption? If you say, therefore, dispatch is something alien to the whole idea of mining operation, I said, therefore, you're looking at a bare bone with a dog will have to bite. We're not looking at that at all. Therefore, the Parliament thought, in order to understand that a delegated authority will be able to make good all those dimensions which are latent. So the whole idea of a sustained production of minerals contains all those latent meanings which the court will look at. If the court were to say that, no, I want to look at it from a narrow point of view, I said then it will completely demolish and annul the parliamentary intent in now going to an entire paradigm shift in making available the initial mineral wealth for subserving the common good. So that's not certainly the parliamentary intent. So mere fact that somebody can argue, Parliament could have expressed the intent better.
That is, what is latent should be patent.
So therefore, merely because Parliament did not use the language you think should have been used. So if these meanings can be gleaned from the context and the intent behind the entire paradigm shift we're talking about, then the court will say, we lean in favor of reading it that way. So therefore, sustained production of minerals, because the argument advances, look at the use of the words in section 4A, dispatch and production, you don't find it here. Therefore, rule 12A travels beyond 4B. I think they're all very narrow way of looking at 4B. So I would probably urge the court to look at 4B from that larger constitutional and economic, interest of subserving the common good purpose of it. And it says also further, prescribes such conditions that to be necessary for commencement and continuation of production. What do you mean by continuation of production? You don't continue to produce and keep them stored them. You have to make it available to somebody else. So therefore, the sustainable rate of production means carries with it a necessary concomitant of sustained dispatch. So minerals are not produced merely for being produced. They are meant for dispatch. Therefore, all these aspects, I think, are built into the understanding of the whole operation of the MMRD Act itself. So 4B now thought, since I am going into an auction process, let me make it more clearer that once you get into the auction process, become getting a mining leaseholder, what are your obligations? So 4B has been enacted to ensure and to make it clear that you are entering into a new scheme of auction, but subject to what the government and the state will now demand from you. The state will demand from you a sustained production of minerals. To say that I can't be part of a demand for the state means that you don't get to the contract at all. So let me now read in this context section 4A and why 4A stands a different footing compared to section 4B. If your lordships recollect, even earlier in the section 4A, we always had the revival application. Somebody who is not able to produce comes and makes an application for revival of a lease. Then law said, well, for a year or two, I'll give a revival, or it may lapse, and so on and so forth. But since, as I said, the paradigm should make it important for even a mining leaseholder to be very clear as to when a lease may not be revived or may not lapse or may lapse. A little more precision was thought, I think, was to be brought into the statute. Because in the absence of the words production, despite in the context of either a lapse not being considered or revival being considered, the precision that is required in order that vagueness is not said to be a issue against them. Therefore, Parliament thought, let's make it very clear. This object and purpose of section 4A is different from 4B. 4A is in the context of dealing with revival requests. So we are moved away from mere mechanical revival requests to a more dynamic revival request. When therefore 4A is a move away from the old mechanical revival respect, it look at the performance. If you look at the performance of a party, therefore, in order that tomorrow you are not told your lease will be terminated, I must have a little more precision. The termination of a lease stands in a different footing. Therefore, the precision required and the express mention required of when I may stand danger of my lease being terminated, I say production and dispatch. Therefore, to say that in the absence of those words, either section 4B, either part of the Act, means that those provisions are vague or did not comprehend production dispatch. I think that's why I said it's a very artificial construction of section 4. So 4A had to necessarily have those words because I said it's important in the context of a possible or a future termination. Nobody can be heard to comply, oh, this statute is vague. I did not know how I'm exposed to a termination question at all. Therefore, in order to obviate, to avoid the situation, Parliament said, I'll put it very clearly, if you're going to face a termination, it will be in the context of your obligation to produce and dispatch. Therefore, if I'm right in my submission, that Parliament now intended that the entire mining operation, as said, as a series of set of operations. And they must be on a sustained basis. each one of them constitute an important stage of the mining operation. You take away one, I think that you collapse, the rest of it will collapse. But I would probably think that the sustained mining operation is the hub of a wheel. And you have so many, all these production, dispatch, etc. The rings of the wheel. If you take away each one of them, I think the hub will collapse. Hub will have no sense at all. Therefore, I would probably urge the court look at phobia as what Parliament now intended. As I said, in the context of the paradigm shift, Parliament intends is now the entire gamut of mining operation shall be subject to a new framework of regulations. In order that 297 and 8 section Article 39B, those ends are realized. Any other way of looking at the move from the original, the old scheme of the Act, I think will take away the life of the Act itself. So I will get into this purpose of construction a little later. We invite you lordships to see Rule Section 4A for the time being. I just flagging my broad submissions. I'll take your lordships into the statute and the rules a little later. Section 4A, more importantly for us, I would say the subsection 1 of section 4A. It's all about whether central government, after consultation with the state government, is of opinion that is expedient in the interest of regulation of mines and mineral development, preservation of natural environment, control of roots, prevention of pollution, avoid danger, communication, or to ensure safety of buildings, monuments, etc., or for maintaining the safety in the mine, such as the purposes. Now, each one of them constitute the aspect of mining operation. So, right from the mineral development, regulation of mines and mineral development, right up to the end, each and every one of them. Then what will the central government may do? Central government may deem fit, it may request the state government to make a premature termination of a prospecting license or an exploration license or a mining lease in respect of mineral other than a mineral area, etc. Then subsection 2, where the state government is of the opinion, is expedient in terms of regulation of mine, the same set of facets of thing repeated here. So the state government may also make a premature termination. And this is part of the old section 4A as originally stood. Now we come to subsection.
So the power of the central government and state government are
for mining lease. I'm sorry.
I think the power of the central government and the state government are coextensive. They both can independently take a decisions, bearing in mind the core fabric of the entire scheme.
Yes.
That is what. Because in subsection 1, once the central government is of the opinion, then the state government has no role to play to put his own opinion. It has to.
Those are minor details of what 4 you had to work.
Sure.
What are they will work? I'm looking at subsection 4. Where the holder of a mining lease fails to undertake production and dispatch for a period of 2 years. This, of course, was brought in 28th of March 2021. So production and dispatch for a period of 2 years after the date of execution of the lease. Now, I asked stop here for a minute and said, if the provision had read like this, where the holder of a mining lease failed to undertake mining operations, it would have made no sense at all. So there has to be some kind of a duration with reference to which the failure will make some sense. Therefore, it talks about fails to undertake production dispatch for a period of 2 years after the date of execution of the lease, where having commenced production and dispatch, has discontinued the same for a period of 2 years. It was important that the Parliament thought, in order that the mining operation, the expedition, and the interest and the dispatch issue is taken care of. Because I'll give you 2 years to find out, will you continue or not? Will you commence or not? And after the commence, will you continue the same place or not? So this is why in that context, Parliament thought production and dispatch expressly has been brought about. It's not merely mining operations. Suppose then you have been very big. You said, I'm carrying on mining operation. You can't terminate it. You can't deal with the mining lease at all. Therefore, in order that there is a certain amount of precision to be brought in the context of possible termination of a mining lease, expressly production dispatch have been brought in there. So it's in the context, only in the context of termination, possible termination of mining. Therefore, to say that these words having been introduced in section 4A, no, look at 4B, it doesn't even look at it remotely. Therefore, 4B doesn't even contemplate dispatch. I think it's a very artificial way of dealing with section 4B in the context of 4A. 4B and 4A operate in two distinct set of spheres. 4A is only about possible termination. And therefore, the express use of the words in the context of 4B. But if 4B is about the larger framework of an enabling power for the state to ensure that the mineral wealth is available for any consumption on a sustained basis. Therefore, it's an entirely different purpose altogether under section 4. The two sections can have no comparison at all. They're two different classes and spheres of operation. Now, I will come back to 4B. Since it talks about 8B, we will also notice that in the earlier regime, you apply and then you have to go and have several clearances over a period of time. Now, in order that when a person now gets into an auction, a platform is made available for an early and expeditious exploration operations. 8B says it's a facilitating provision. Now, 8B, which is referred to in 4B, let me read 8B. Notwithstanding anything contained in your act or any other law for the time being in force, all valid rights, approvals, clearances, licenses, and the like granted to a lessee in respect of a mine other than those under the Atomic Energy Act and the rules made thereunder shall continue to be valid even after expiry or termination of leave and such rights, approvals, clearances, licenses, and the like shall be transferred to and vested subject to the conditions provided so and so to the successful bidder. You get something on your platter. You get something on your platter to say, now I'll continue operations immediately after become a successful bidder after 2015 or 2020. Then kindly see the proviso and then I'll read subsection 2. Provided that for an expiry of such lease period, mining lease has not been executed pursuant to an auction under the provisions of subsection 4 of section 8A or lease executed pursuant to such auction has been terminated within a period of 1 year to its auction, the state government may, with the previous approval of the central government, grant lease to a government company or a corporation for a period not exceeding 10 years or so and so, whichever is earlier. And such government company or corporation will be deemed to acquire all valid rights, approvals, clearances, licenses, and the like vested with the previous lessee. So whether it's a private mining operator or a government, now they are put on the same pedestal so that the mining operation can continue without any disruption. Now let us look at subsection 2. Notwithstanding anything contained in any other law for the time being in force, it shall be lawful for the new lessee to continue mining operations on the land till the expiry or termination of mining lease granted to it, in which the mining operations are being carried out by the previous lessee. So once you get it, and undisrupted working environment is now assured to you.
Sorry.
Problem. That's true. I thought then I can continue tomorrow with port permits.
No difficulty. Let us continue for some time. Let us see.
So we,
Let us see.
I was pretty point actually there. I just briefly put the course to section 4A and then 8B. What is it, sir? If section 8B as it originally stood prior to its amendment, there was one subsection 3 of section 8B. If you like to have this commercials edition,
No, I think this book has.
commercial edition.
Is more difficult. It has
So
at the bottom the unamended provision is there.
Yeah, at the bottom we have the unamended
Yes.
provision.
Correct.
So if you look at subsection 3 of section 8B, today we don't have that subsection 3, we have subsection 2. Subsection 3 as it then stood reads like this: notwithstanding anything contained in any other law for the time being enforced, it shall be lawful for the new lessee to continue mining operations on the land in which mining operations are being carried out by the previous lessee for a period of 2 years from the date of commencement of the new lease. So the 2 years has gone now. Subsection 2 is now for the entirety of the mining lease period, as it now stands. All that therefore means, in my understanding, so the lessee who comes into position post 2015 and definitely after 2020 has several advantages and benefits which come as a package. And but for that advanced benefits, you will be spending your resources, investments, so on and so forth, getting clearances. Therefore, in order that the sustained mining operations are carried out with all the possible process of aid, assistance, and support, therefore, 4B will receive its reading, keeping all these aspects in mind. I'll take your lordship's a few more provisions before I probably continue tomorrow with the permission of the court. I was also trying to canvass this proposition that sections 13 and 18, which enable the governments to make rules, must be read as one composite set of provisions. Because after all, if that section 13 talks about rules in regard to grant of mineral concessions, I imagine even if section 18 was not there, 18 talks about sustained mineral development and all that. Even if section 18 was not there, the grant of a mineral concession can include all those aspects and dimensions which will relate to mining operations and incidental and ancillary necessary thereto, so on and so forth. But since 18 and 13 seem to occupy distinct rule-making sphere, but if one closely looks at 13 and 18, there is some overlapping, and it's bound to be so. So we have certain statutes where a rule-making power occupies a different sphere, a regulation-making power occupies a different sphere. So we can't say draw a wall of separation between 13 and 18, and therefore we'll say, well, a rule can be takes a 13 and not 18 or vice versa. Therefore, the law is well settled that whether a source of authority is mentioned or a wrong source of authority is mentioned, it ought not to make a difference at all, as long the source of authority is traceable somewhere. So I was also trying to say that 13 and 18 distinctions may not be very helpful. And let me quickly go through Rule 12A, read it, and then probably I would like to read a few more provisions. Let me do it. If I am right in my reading of section 4B that it is an enabling provision, and all enabling provisions will be given widest possible reading. An enabling provision keeping in mind, as I said, Article 297 and Article 39B. if that enabling provision enable the government to prescribe such rules or regulations as the case may be for sustained mineral operation, the entirety of the 2016 rules will have to be read keeping that in mind. You can't pick out one rule in isolation and read it in isolation. Therefore, it appears to me from the way the 2016 rules have been enacted initially, and thereafter it has undergone several changes. So we have the old mineral concession rules, which is very widely worded, and now these 2016 rules occupy certain special provision. I think there is something which is old vintage and also some current developments which the rules take care of. When I say the old vintage, we have a rule 6 in the 2016 rule, which is at page 548 of this. It talks about renewal of a prospecting license. But then now 4A, section 4A, in fact, addresses it now in a different way altogether. So old vintage is there, but like, for instance, again, rule 9 of this rules talk about composite licenses. But when you come to rules 9A, which is relatable to section 8B, I look at sub-rule 4 of this rule 9A and then sub-rule 5. In case the new lessee proposes any change in the conditions attached to the approvals, clearances, license, permits, and the like transferred under the vesting order, the lessee will obtain the approval of the same under the laws for the time being in force. Therefore, if the laws for time being in force says you will be subject to the following demands and conditions, you will to abide by them. You can't say at the time I entered in a mining lease, these were the conditions, I can't be subjected to some external conditions now. You can't say that. So similarly, so sub-rule 5 is more or less in tune with subsection 2 of section 8B. Sub-rule 5 reads like this: it shall be lawful for the new lessee to commence and continue mining operations on the land in which mining operations were being carried out by the previous lessee after the execution lease deed till expiry or termination of the mining is granted. Subsection 2 of 8B also talks about that. Then I said the new developments are found in rule 9B, which talks about license granted through auction. Then 10A is also in tune with that. Kindly turn to rule 11 for a minute before I go further. Every prospecting license, composite license, or exploration license shall, in addition to the conditions specified therein, be subject to the following conditions. The licensee may win and carry for purposes other than commercial purposes. So, for instance, for your own captive consumption.
Yeah. Yes.
So, what is the meaning of the word carry? To take it away from the mining area. And then if you do it for your own captive consumption, it is not for any other commercial consumption like trading in mineral, but then you still engage in a commercial activity of using it captively. So the carrying part of it, so integral to your mining operations. Why? So in a captive consumption, will you still hold it in the place where the mines have been operated? Certainly you will not. So the question of taking it away after it has been mined is so integral to the mining operation. So you will find more provisions like this. I'll make a tabular statement of them showing that this carrying away, then merchantability, marketing, etc., will find some position somewhere or the other.
So sub-rule 1 of rule 10, the rule 11.
Yes.
It talks about, I think, the statutory conditions, despite being conspicuously absent in the mining leases, but is ingrained as part of those mining leases.
kindly turn to Rule 12. Rule 12, subclause F of subrule 1 of Rule 12. This is a 9. The lessee shall keep accurate and faithful account showing the quantity and other particular of all minerals obtained and dispatched from the mine. This is prior to 12A. So these are the terms and conditions of a mining lease. Obtained and dispatched from the mine, waste material so-and-so, number so-and-so, etc. And then it says, and records maintained by him and shall furnish the central state government such information return as it or any officer authorized may require. So what will the central government require from them? How much of mineral wealth you have extracted? What purpose will it serve for me to ask this information? Unless how much has been transferred and shared and sold in the market. I also found that these very detailed terms and conditions of the mining lease under Rule 12, many of them, I think, have corresponding provisions either in Section 13 or 18. I'll also give a tabular statement of that so that the court has that clarity on why 13 and 18 must be read together. Then when we come to 12A, I just quickly going through it. Lord will permit me, I prepared my written note and tomorrow I'll continue with on the basis of my written note. So the scheme of 12A, why do we need a 12A at all? If 4B has to be read in a truncated manner, namely it's only about how much you will mine and store it at your place, then I don't need to care about anything else. Government need not worry about anything else. It is no other concern. But can it work like that? So the government is certainly concerned about how do you really thereafter transfer it to the ultimate consumers. So I must have a regulatory framework in place. So how that regulatory framework will be reasonable, rational, then one can probably look into it. But I'm saying even that will be a matter outside the scope of arguments in this case because you entered into an agreement with Rule 12A being integral part of an agreement. So if in the absence of Rule A, after it's been amended in 2020 and 2021, I find it's an important regulatory framework which ensures and enables the government to say that how do I follow what exactly you're doing in the mining operations? And to say that leave it to me and my market assessment, to my suitability or otherwise of my market assessment. And therefore no regulatory framework can come in at all. Which means dispatch is my part, don't look at it. So can anybody say that having entered into an economic transaction like this, having, I said, flagged that larger dimension, does it lie in their mouth to say that, look here, now it has become unprofitable to us, or it will always remain unprofitable for us? We will be the masters of how we will carry out the mining operation. Forget about the agreement. Therefore, in this context, I find the very specious argument has been advanced saying mining plan governs everything. I do not know whether the Bureau of Mines is the master of everything about the mining operation. It's only about technical details. If today, even if the Bureau of Mines has to be given this job, and that, well, government may say, all right, along with the mining plan, tell them how will they mine, how will they produce, how will they dispatch. Will a mining plan only talk about how do you have a safe, efficient extraction of minerals? If that is the only job of a mining plan, you can't bring into it anything more beyond those minimal details. So the mining plan is about efficient extraction of minerals with all other safeguards, securities, etc. for the working of them. But to erect the mining plan on a higher pedestal to say agreement, rule, regulation, notwithstanding, I do not know whether the court will follow this argument. So in 12A, I find rules 1A, 1B, and 1C came much later, having found that there is a need for, again, a smooth transition so that the penalty will not become harsh. So I'll explain the court tomorrow and why the penalty has to necessarily come in. If the question of penalty which may receive a strict scrutiny, when you put it like that, then the other part of Rule 12A cannot be put on the same pedestal. You may have a problem with the penalty. But then you can't say, therefore, don't ask me to dispatch according to a regulatory framework. So whether you are being asked to comply with a regulatory framework, but while that's probably workable, but to say the penalty is too hard, disproportionate, etc., one can probably understand, though I'm not conceding that. So you can't start from the penalty part of it and say the entire rule is bad. So Rule 12A, as far as I see, even the sub-rule 2. Now, I find that there's an argument advanced that it is vague and too vague. I'll probably place an illustration to show how it is not vague. Let me read it. The new lessee shall ensure that the annual production beyond 2 years from the date of execution of a leave use is equal to or more than the annual production by the previous lessee. There are many lessees here who are previous lessees. They are not new lessees who have to encounter new problem. So the previous lessees here, all the facilitation. So the previous lessee know how the mining can really take place. Therefore, this rule talks about 2 years is a reasonable period. From the date of execution of a new lease, you will have to say equal to or more than annual production by the previous lessee and shall subsequently work out and implement an annual production. Therefore, a freedom is given to you. You have the obligation to find out how will I have an annual production in the future, having done a 2-year production and dispatch. So some element of discretion is available to you. So the annual, you will have a workout and implement an annual production to ensure that the mineral resources are fully exploited during the period of the lease. Suppose I can produce 10 metric tons today, and the entire mining area is only 100 metric tons. So, and I say every year you will produce 10 metric tons. The previous lessee has been doing that. I'll produce within 10 years and exhaust the mines. So the question is current requirements of the nation to ensure that there is a continuous supply of mineral wealth. That is the theme behind sub-rule 2. And how do can it be possible that somebody argue, oh, this theme is alien to the entire act? May I then continue tomorrow, subject to Lordship's convenience?
Yes.
So tomorrow is very good.
Yes.
We presume that the learned advocate general will follow after upon the learned AG, or
I think the Attorney General is, we will complete. I think the arguments will be there. No.
Yeah.
No. He wanted to understand that after the London Attorney General completes or finishes his, concludes his argument, whether the London AG will argue. This is what he wanted to ascertain. I say probably he's there to cover all the points. And we have a trust and a hope that he will not leave any.
No, I had a word with the advocate.
Yes,
I think
he will not leave any stone unturned. He will turn all the stones. So definitely tomorrow, if you want, no difficulty.
As far as the demand notice are concerned, of course, it's the domain of the learned advocate general. He will certainly like to advance some more argument after they have concluded.
That will be definitely dependent upon your
entirely
argument.
on the rule issue and the statute.
So that will be dependent upon, because the rule issue, their mean, I think the crux of the argument was on that. Actually, if the dispatch part is segregated or omitted or eliminated, in that event, they say that everything will go. Actually, everything is founded upon that particular dispatch part, if I correctly understood.
Absolutely, that's one of the main grounds.
So that is what they wanted. Their argument. Definitely come tomorrow, I think.
Obliged.
Some unusual circumstances can't be avoided.
And tomorrow is a past day.
Yes. Yes, definitely, because all of you.
I was on the lighter side, thinking, was it only happening? The Attorney General came here in Cuttack and something happened here.
No.
It's happening all over the country.
No. It is a pan-India scenario. No, definitely not.
No, we are fortunate that timely
Yes.
guidance we could get.
But Lord, we're all very grateful that it has been a completely pleasant outcome. We're very grateful.
Because the interim order may continue, please.
Yes. This is a pan-India scenario. I do not know what is. Anyhow, we don't show any complacency nor reluctancy, but also equally that we are not perturbed with this. We are still to uphold the system and to make the system workable.
That's right.
So, definitely, yes. Tomorrow, first matter, there is no difficulty. Yes, whatever, who is there.
That's my interim order.
Yes, definitely it will. Is there tomorrow.
Item 33, sir.
Your Lordship, please.
Yes. So you want to withdraw? Yes.
Subaltern 2, because I am appearing in Subaltern 2. Another friend has, for item number 33, Subaltern 2, because I am appearing.
So brother, this is what the notification has to be understood, and then on that basis withdraw. You are also coming with the June of this.
Yes.
No, he is for the respondent. You
And
are
for the respondent.
Oh, I understand. That is, he is saying I'm in item number 2.
No,
Subaltern number 2
stop it.
for the respondent.
Stop it.
Sub item. And who is in a main item? Who is in a main item?
Another friend.
He's for the,
He's for the appellant.
that's why I'm, who is for the respondent?
I am for the respondent
In
subaltern.
main matter?
In the main matter. Not
You
in the
are-
main matter, Subaltern 2.
Oh, I'm asking who is there
No,
in the main matter for the respondent?
main matter notices have not been issued.
No, there's not.
Not issue. Okay, say that.
Sorry.
Sub-item, you are.
And sub item 1?
Your name appears. Then
Sub item 1?
So all items, KDI is for admin side.
I understand. So he is for the appellant. I'm just asking anybody who is representing the respondent, any notices have been issued or not? It is at the admission stage. I just wanted to ensure. Nothing more than
Item
that.
33, है ना?
Mr. Chitrasen Parida,
He was there also.
he was there. Okay. He was in 73 of 2023. 73 of 2023 he was.
Yes, ma'am.
73.
Yes. Wherever names are reflecting, we will record.
Yes.
All other items, notices were not issued, and we will say that you have
We have withdrawn.
filed.
You can, because at the admission stage, if you want to withdraw, we can't stand. We does not think that any notices are required to be issued. Only for some good purposes, the names are to be recorded for the respondent.
Item 33 पूरा
Mr. Chitrasen was there.
It was there.
Yes, all of them are coming within the purview of this.
Pecuniary limits.
That's your stand is,
Below monetary.
yes.
They filed an IAO, say, they filed an interim application for that petition. Based on
We'll
the-
see.
Yes.
We'll see. Wherever the interim applications will allow this, and wherever the interim applications are not there, on the basis of this, we'll no different.
24.
Yes, 24, what is this?
180 ml McEnroe.
Yes. Give. Oh,
लगेगा पार्टी आई मीन
where is he?
ये लड़सी आई मीन VC है
Oh, yes,
ये लड़सी आइटम
no difficulty.
आइटम
No, in 24, are you there?
No, Your Lordship, item number
That
14.
is what I am ascertaining at 24.
It was,
He was there, Mr. Tripathi, Mr. Das, they were there.
Mr. Tripathi is outside.
Yes, call him.
Leonard Friend is also there for item number 3. Something.
No, I understand. I will go one by one. Just,
Mr. Bhaktas, it is one.
don't worry, Mr. Mishra, we are not rising. We are still there to hear the matter. Don't worry. We'll hear each matter.
I'm sorry, actually, I have been evacuated.
Don't. Yes. You have gone home.
He is there. Additional standing counsel.
No, I know. He has gone home, Mr. Mishra.
He is there.
Your Lordship, I have been forced.
Proxy of Mr. Mishra.
No. He is additional standing
Additional
counsel.
standing counsel.
He is standing counsel. He is additional standing counsel for the commercial taxes. We have Mr. Kejriwal.
Tibriwal, Your Lordship.
Yeah, Tibrawal.
Tibriwal.
One and the same.
I always get confused.
Both belong to the same company.
Acha. Okay, then.
Tripathi is coming. Mr. Tripathi.
You have given a similar order.
Oh, 180 ml because
Ah,
only thing is
ah.
we wanted to ensure Mr.
Ah.
Tripathi is here or Ms. Das or whoever. Somebody.
Only
Anyhow,
thing left-
just keep. No, they were here.
They were.
I just called him, he's coming, Your Lordship.
It's
Yes,
all right,
let
sir.
it come. You call the any other matter? What is this?
Yes. Item.
Item 44.
Yes, what is this?
There is a delay in filing the interview minutes.
So have you served the copy?
And also notice being issued to the
Yes, notice. 40,
34.
34. Yes, notice.
44.
You have for the bank.
3-4 or 4-4? 4.
Your Lordship, item
Yes,
number
I-
1.
Yes, right. Donation.
Okay.
Yes.
Item number 14, Your Lordship, I am for the petitioner, Your Lordship. Your Lordship, that is so far as the Service Tax Act 17.
No, you are appearing in 31.
No, 14.
Yes, we'll come, don't worry. 31.
31.
Lordship had protected me only till today, Your Lordship. Today.
So who is appearing? Yes, Office of the Collector and the District Magistrate Puri.
Covered
So
decision.
state.
Your covered decision covers this particular.
What decision covers?
Shifting matters. Ranjan Raut's decision with respect to shifting of the shop.
So let them come, Mr. Das. You are appearing in 31, na?
Even Mr. Tripathi is working. 180
Okay, but you don't have files?
files.
124. 180 ml.
24 is a 180.
180 ml, that is the common order.
24, yes.
Matt,
And,
whatever.
yes. 30.
31 years.
31.
What is the covered order?
Which one previous occasion I followed it. Your Lordship had already passed an interim order in this protecting me, Your Lordship. They were supposed to. Your Lordship had-
What is the final order? Any final adjudication has been made?
Shifting of shop in violation of embargo created under Rule 33(2).
Job is there.
So Lordship had
Excise.
directed
Thomas had
an instruction whether the objection was filed within time or not. So they had passed that 15 days. That is precisely my submission. So they were supposed to file an affidavit today intimating the court. These are the judgments
Yes.
which Lordship has delivered covered.
Mr. Tripathi, the 31, he says is a covered matter.
Let him examine and come back.
Let him protect me for a week or two.
Look, is item 31, we are filing counter affidavit today.
Acha.
Yes. Record that Mr. Tripathi, the additional government advocate submits that the counter
File a rejoinder in the meantime, it's so regular.
1 week time is enough.
Well, it's
In the meantime, it is open to the petitioner to file a rejoinder to the same. Yes.
may extend the interim order.
The interim order is extended till the next day.
If it is there.
If there be any. The interim order passed earlier, comma, if there be any, is extended till the next day.
Gratefully, sir.
Yes, what is the next matter? 14. Mr. Mishra was very,
Your Lordship, Your Lordship,
he was restless. He was mentioning, yes, 14.
I'm not the petitioner in this case, Your Lordship.
Oh, that is why you were restless.
Your Lordship.
Yes.
73(4)(b) of the Finance Act. That
73(4)(b).
That cyanide matter, Your Lordship.
The council is appealing in this case and the file.
Adjourn Senate because the Supreme Court has not decided it.
No, Your Lordship.
It has to be. You are not appearing.
I am not appearing in this case and I have not verified whether it is 73(4)(b).
Give the file and give it to him.
I'll have everything here.
Item 14.
Your Lordship,
Look at the prayer.
73(4).
Shall we record your appearance and direct the office to regularize your appearance? Or you wanted him? No, he's a junior standing counsel.
Junior standing counsel.
And who is appearing?
Exactly, I don't know.
He can appear for the department, junior standing counsel. Now, brief is allotted or not allotted? This has come for the first time. So you are allotted with the brief or
I am not allotted this.
allotted? Who is allotted?
Exactly.
You do not know.
Today morning, I have asked Learned Senior Standing Counsel, Mr. Pusti, that to whom it has been allotted.
He was there, Mr. Pusti?
Not allotted to me also.
Acha,
But
okay.
one of our-
You are senior standing counsel for the service tax? Acha.
And you are also appearing in a service tax.
We have handled.
I'm asking whether he's also appearing in the panel. So this brief has not been 73(4)(b).
Lordship. My colleague is appearing.
I am appearing.
Acha.
And sub item?
Matter, I am.
No difficult.
Item 4.
Mr. B.A. Pusti, first item.
First item.
First time there KDA.
I am appearing.
Oh, that is what he's saying. First item, Mr. Kedia, and the all sub items, Mr. Pusti. What more?
Lordship, item 4 is also 73(4)(b).
4. Who
Yes,
is
Your Lordship.
appearing?
Item 4.
Who is appearing?
Sujan Rai Chaudhary, he has filed his power.
Okay.
Mr. So Mr. Sujan is the
Is there?
Mr. Sujan.
Is it 73(4)(b)?
73(4)(b), Your Lordship. Item 4.
Four.
Yes, same order.
Yes.
Item 17 also 73(4)(b), my lord.
Who is appearing in 17?
79.
Yes, the same order. Next.
Oblige, your lordship.
Lordship, item 7. Item 7, Your Lordship, can I request to come in tomorrow, Your Lordship? Item 7 in today's list.
Wait. 18 has been requested.
Item 18.
RC cancellation. Who is appearing? No difficulty. Next. All sub items. You are appearing.
Matter, my learned senior is appearing.
And what about sub items?
Sub item, I am my learned friend is there, Your Lordship, additional standing counsel.
Write in a slip. Okay.
Third matter, art matter, it is allotted to Mr. Mukesh Sharma. Yes.
Where is he?
He was there, Lordship. In the morning, he was there. And after cancel.
You give given a slip.
Yes,
Which item, number you give,
Yes.
so that we will record that.
I have mentioned
Yes. Any other item?
Yes, Mr.
Two. What is this? Oh, 70. Who is appearing in 2? Yes.
Item 15.
What is that?
15.
15. Who is appearing?
Your Lordship,
Mr. Tribunal.
15, we are appearing.
We are appealing.
Mr. Tribunal is
So, MRC cancellation.
Sit down.
Okay, 15.
Item 19, your lordships. 19 also RC cancellation. My lord, I beg to appeal.
Noted item.
Which one?
Item 19, your lords.
I am appealing.
19?
RC cancellation, your lords.
Yes.
Oblige.
Item 28.
28. What is this?
Single proceeding covering multiple tax periods.
Multiple. Yes.
Item number लिखी
Yes, ma'am.
दे दिया तो.
Yes.
Appeal question.
Item 7, your lordship.
What is that?
Item 7, your lordship, is related to an income tax PAN related issue. May I pray for it tomorrow, your lordship? If it can come tomorrow.
Is it so urgent that it cannot wait for next week?
Your lordship, next week. Your lordship.
Next week. Yes.
Grateful, Manoj.
What is that?
I think the 3 Lord is a fresh matter where the challenge about gross violation of principles of natural justice.
Gross violation.
What has happened?
Or a flagrant violation. What is?
Flagrant.
great respect
Of gross.
with great respect to my Lord and Senior. Your Lordship, I have a preliminary objection in this case so far as the entertainability of the case, Your Lordship.
Why?
Your Lordship, here the order has been passed on dated 6th January 2025 and the writ has been filed in the month of September 2025.
Lord,
That reason, so far as the Glaxo case is concerned, and Your Lordship
I'll explain.
kept pending a
What has happened, Lord, in this case?
Well, I understand.
What has happened in this case, Lord? If I meet my learned friend's query first, so impugned order, Lord, was first passed on 6th of January 2025, and 3 months elapses on 5th of April 2025.
Yes.
Lord, the entire issue was that they pick up some figures from my vehicle records and report, and they say that this is not tallying with 3B. I file a rectification within 3 months. And say I produce all my e-vehicle registers. I say that X, which you have quoted, is not the figure. What my figure is, what I have disclosed in the returns, and there cannot be any extra demand on that. Without giving me a hearing, the rectification application on a very specious ground that I have mentioned the date of order of
When is the date of the order on a rectification?
Rectification order is 15. It was filed on 15/4, and the rejection order is 20th of June 2025.
20th of June.
And I have filed my writ petition in September. That is within the 3 months.
3 months. So you are really aggrieved by an order passed on a rectification application?
I am aggrieved, Lord, because right from the show cause stage.
No, I understand. Recently is that once you have approached to the authority with an application, with a rectification application, then at least the authority must afford an opportunity of hearings because you have all the documents you will produce. So your grievance is that the authority did not provide you an adequate opportunity of hearing in the rectification application and everything. So according to you, this order rejecting your application for rectification is violative of the principle of natural justice.
This violation begins right from the very beginning.
True. That is, you have already raised in a rectification application. You have not.
Rectification was for a very limited period. That the entire issue from which this extra demand has been made, basing on the e-vehicle register, is a report. Sorry.
Under an impression that if rectification would be allowed, your demand will be reduced.
No, it will be
Zero. So it is better to go and pursue your rectification application.
No. What has happened? Your Lordship would
Or simultaneously you can go for an appeal if it is not allowed.
Your Lordship may appreciate, Lord. Here, what has happened in this case, that right from ASMD 10 till my Lord's final order, all these were, Lord, uploaded in a tab, which is known as additional note.
Mr. Kaur, you are aware that we are in the process of being consider or in being decided the particular issue, whether entertainability or the maintainability cannot be entertainability part. So we cannot, but only one thing is, well, once you have come within 3 months from the date of the order rejecting your rectification application, and if we find that it is violative of the principle of natural justice, then naturally the court may interfere and entertain your writ petition. And if you can convince them that there is error which is there, rectification is required. Zero at if the entire demand becomes zero,
My submission,
then what
my
remains?
submission would be, my lord, that this
It still insists for a natural justice.
natural justice, because if I
If the demand becomes zero,
look, what has happened in this case? They say that there is no error apparent. Immediately they pass that order, my lord.
That is
And
what
then my
I'm
lord
saying.
tried to argue that this is an appellable order. Then, my lord, I do not, my lord, my primary stand, my lord, that this particular aspect of loading it on the additional tab, my lord,
Your Lordship may kindly look into. Your Lordship may kindly look into the rectification application.
never got the notice. I think it's an ex parte order. No, Lord, it was an ex parte order. Notes. What has happened in this case that because of the wrong posting in the additional notice tab, notes, which was now till date, wrong posting of the notices and the order uploading of the notices, the additional tab, additional notices tab, and this particular portal, my lord, does not show. It is only the notices and orders which comes to know. And if the Lordship would permit me, I can also demonstrate that till today, because my learned friend would make a submission that they have modified the GST portal. No. It is not done. It's not gone to module 4 or whatever which my learned friend would say. It is only notices and orders which is coming up, the portal. No. This additional notice and orders is not coming up at all. No. And all these notices and the main order were posted in the additional notices. And a number of high courts now they have remanded back those matters on the specious ground that there has been a violation of principle of natural justice. Yes. Small compilation, Your Lordship, and it permits me. And you also. Small compilation, Your Lordship, and convenience. Your Lordship, kindly see the judgments of different high courts on this point of posting in the additional notice tab. They have said,
Probably you could not get it. Actually, we are not on that score. We have one of the best case. But if so far as the interchangeability is somehow curbed or being taken away, then even if you have the good case, will the court entertain such a proceeding? What is the purpose of incorporating the Limitation Act to a legislation? That every action before the court must be in a time-bound manner. If somebody approaches the court beyond the time, even if he has a good right, but the relief which he sought for cannot be extended to. It is not, Limitation Act does not destroy the right of the parties. It only curbed or denies the relief from the court. So that is what I'm saying. We are more on a basic point of interchangeability.
Your Lordship, I have not.
And you are also one of the council who is pondering upon the thing that how to come across, or we can make a line of distinction.
But in this case, my lords, in my
there is two aspects. I tell you, this case can be disposed of on one day. That since you have already approached the authority with the rectification application has been dismissed without following the procedure of law, I mean the natural justice. That the board, and you have come within the time when the
earlier
is
also
provided.
Earlier
so there is no difficulty.
But earlier also, pursuant to the final order, within 3 months I filed a rectification. So if your Lordship would see the
only thing is that what has come. The question is again that whether the time of an appeal against a parent order stop ticking as you have approached the rectification.
I have been a vigilant litigant. I have been a vigilant.
I'm telling you, there may be one possible argument. Even the original order is rectified to certain extent, then it may invite a fresh lease of life to you to challenge that particular parent order.
The Lordships are very correct.
And your Lordship, kindly look into the rectification application and rectification order on a flimsy ground. The rectification application is that. And that cannot be merged, your Lordship.
Additional notices.
Don't say so.
Yes, sir. Additional notices, they are sending the notices. Many of the groups have.
That's true. That's a good ground. I'm saying that you have one of the good case.
But on that score, it's alone, my Lordship may allow my writ petition and send me back to the assessing authority.
And in one of the cases, it is scanned and.
Yes, that
We
is the
can
latest.
send you back for rectification.
My difficulty, once your Lordship would send me.
No, we are on level to have some resolution on this.
Lordship would appreciate a particular client who's paying more than 200 crores every month to the government exchequer. I'm not doing any charity, Lord. I'm doing business and I'm paying it. Are they close to Lord? Kill the goose, Lord, that lays the golden egg. That is the least minimum, I would say, Lord. The proceeding began in the Lord on 6th of January 2024. Till 6th of January 2025, no further communication to me. The first communication comes in my additional notice tab on the 6th of January 2024. And the final order is uploaded in the additional notice tab on the 6th of January. When I go to the office in April, they say that such a notice has been and an order has been passed against you. And what you are going to do about it? And then, my lord, when I ask where it is the notice, they say, please check your additional tab. Thereafter, my lord, on checking my additional tab, I get all these notices right from the notices to the final order. All, my lord, posted in the additional tab. And all high courts, my lord, and this, my lord, would be a serious prejudice, my lord, to the assessment.
That's why Mr. Mishra did not utter a single word on the merit.
And if my learned friend,
Even I have not gone to the assessment order.
no, Mr. Mishra would be gracious enough to direct his officers that please go through the e-waybill reports, compare it with what my 3B returns and 9 returns. And if you find that there is no discrepancy, my lord, allow it. Because there they will take a stand that if we allow your rectification, it will amount to a review of the order.
With great respect,
and then they throw me out.
Look into the rectification application.
Your lordship will see the entire scenario, my lord. If they, my lord, entertain my rectification application, they will not at all reduce the demand or even touch it. Because they know for sure.
Not even 1 rupee.
No, my lord. Because they know that my e-registered, my lord, is going to tally with my returns. And there can't be any discrepancy on it.
So, if you produce those documents and you're given an opportunity to record it,
and if your lordship would record,
then what?
Then if the lordship is gracious enough.
State when assessment order gets ex parte or without production of this form. Once 161 petition is filed, whether at all, there is absolutely whether at all there is absolutely prohibition on the assessing authority to examine the books of account and see whether the demand raised ex parte is correct or not. And if they find that there is error kept in the ex parte order, then can't they rectify to that extent, saying that the assessment order will merge into this.
I bow down your
they rectify, then it merges.
My humble submission will be that particular observation which falls from a lord to lord. If it will be there, my lord, they'll definitely do it.
No. Any error?
No, can we?
Otherwise, your lordship may see the manner in which they have done it, my lord. We forget about my natural justice party. Your lordship may kindly turn to page 50. The manner in which they have dealt with my rectification act. Page 50 for your lordship's time convenience, my lord, page 50. They say, my lord, rejection of rectification, your lordship, page 50. Rejection of rectification order. Your application of rectification so-and-so dated 15/4/2025 and demand order by the DRC 07 number so-and-so is hereby rejected for the following reason. And your lordship may see the reason. You have mentioned that the SCN and the demand order has been issued on the same day, that is 6/1/2024, which is wrong because the SCN was issued on 26. This is also wrong because it was issued on 6/1/2024, issued on 26/1/2024, whereas the demand order was issued on 6/1/2025. Then they come out, extract 161, and then they say, since your application for rectification for demand order is rejected, you have to either discharge the liability or appeal to the High Court. So they have not discussed, and if your lordship would see my rectification application, which is at page 86.
Let this order, if this order goes, let us proceed on this basis that this order goes.
And a further direction.
Then what? You have to approve these.
I'll approve.
On what? Rectification application.
True, madam. But if that particular.
Go there, produce those records, and if that decide, give a reasoned hearing, give a reasoned hearing, give a reasoned order. What do you mean? We are proposing the same thing from the very first.
If your lordship,
Mr. Kaur, but you were not agreeing on anything. We were proposing from the very 30 seconds we were proposing.
I'm sorry, my lord, sir. Maybe I was not
fixed up with carried away by some emotions and something because of this additional tab and the supplementary or whatever that tab.
That is the main issue, my lord. That's
so
the pan-Indian.
By that tab.
That's the pan-Indian.
He has already tested the pulse of the department for the long time.
And if your lordship would see my application, Lord, at page 86, I specifically
say. We are saying that whatever they authority will consider to a personal hearing, will decide by recording the reasons. What more than what we were impressing upon you.
That's perfect. That's perfect, Lord. Let him examine.
If documents are with him, already there on the board.
It's on the portal. On the portal.
Uploaded, he has the access. He has the access. You have to only demonstrate before you that these are the portal figures which you have not verified during the course of assessment. Now you look at it.
That will solve
and rectify it.
That will solve my
accordingly.
That will solve my
What we have seen.
No, that will solve my problem.
Only
Sorry, you were not understanding within 30 seconds.
I was perhaps my grey matters were not
No.
very much receptive to matters.
No.
Your Lordship,
Your Lordship would appreciate that.
So Vishnu, he is within time.
Your Lordship, so far as the 161.
We are more concerned with the rectification order.
Your Lordship,
Reason? Any reason? There is nothing in the record. Will you not give the opportunity? Will you
so far as the 161.
Mr. Mishra,
Application is there.
Mr. Mishra,
Yes.
Mr. Mishra, quoting the provision of the statute, is it a reason?
Your Lordship,
Accepted.
Your Lordship, with great respect, I am not supporting the order. But Your Lordship, so far as the law is concerned, Section 161 is very limited. Your Lordship, error apparent on the face of record.
So what more error? If the documents which are there available to you on the portal, will you not go and see? We will make an observation in this regard.
No, Your Lordship.
This is what one can have the error apparent on the face.
Mr. Mishra, you have invited.
You have invited, then we are making observations.
Your Lordship.
This is what more can be an error apparent on the face of the record than this, that everything is there on the portal, accessible to you, and you have not considered those documents.
Mr. Mishra, Kiran Stone, I have referred in one of the cases, following my source.
Your Lordship, with great respect.
Yes, it is for the assessing officer to look into all these things, whatever relief to be granted, even if he has not claimed in the returns. That to that extent also I have observed in one of my judgments. Perhaps you have not noticed that. And refer to that also.
Your Lordship, with great
And
respect.
it is your assessing officer who is duty bound to look into all the records available with him, which are already filed along with returns and uploaded.
Your Lordship, I am not supporting the order under Section 161.
No, definitely not.
Mr. You have,
The moment you go and say your argument is advanced, then we'll take care of that.
Your Lordship, I am not
We
supporting.
will take care of that. We'll take care.
From the beginning,
But what more the error could be perceived from the which is apparent from the record.
and Oryx and Karanti Associate,
Your Lordship,
both are staring at you, and Shukla brothers.
order under Section 161. Let him appear before the authority. His 161 is pending, Your Lordship.
No. We
It's
will
not pending. You are
still
disposed of
further-
in this
we
way.
will-
Fashion, not recording anything.
Your Lordship may quash that order. Your Lordship may set aside that order.
Mr. Mishra, you have invited, we have go still further, making your assessing officer pay costs.
Yes.
For having done mischief in this case. This additional tab business.
Yes.
Choice is yours.
No.
Yes. So this
He's
is
he's so restless. He wanted also to do it. That's the whole problem. Anyhow,
so there is no reason. There is no reason.
there is no reason. 161. Let it go and decide.
Both the way you will pass ex parte orders. What is the fun of doing this? Is the dealer not doing his business in Odisha since long? He is your registered dealer.
Your Lordship.
Then
Yes. Anyhow,
he is skipping away.
Protection. Okay.
if the order goes,
No, the order of protection goes, but the original order stands.
Mr. Kaur, then you are really hitting my conscience, which I have decided very, very, very in a stronger way that the court should stay away from giving any protection while disposing of the main. If you want, I can give you a Katina. I have also relied upon Katina of decisions of the Supreme Court that no, if you had a protection available to you during the pendency of the rectification application, that would be revived the moment the final order is set aside. If it is not, then we will not give you further protection.
They have not now kept that.
I do not know. Whatever.
The ban is there, let it continue.
No, I cannot say. We will, if we set aside the final order of rejecting your rectification application, that means it will be deemed that the rectification application is pending before the authority. And if it is if any protection is available to you during the pendency, it is available to you, but will not pass anything.
Let it be that.
Your Lordship may fix a time period.
Yes, time bound. We want time bound.
And then cooperation from the petitioner.
Yes.
Cooperation from the council for the department as well.
I'm grateful.
You ask your officer.
Ask your officer.
To conduct well.
He wanted to dispose of within a time. He will not cite a ground that we are grappling with so much of pending matters.
My Lord Justice Raman was my predecessor, Your Lordship. Your Lordship, he was handling all the officers for a longer time.
No, I was never handling.
I have learned everything.
They were not under my control. They are control of commissioner.
Yes, disposed of.
I'm sorry, but I was not in the same wavelength of your Lordship.
It's produced, page 36, the OPD.
Your Lordship, he has produced, but I think this could not reach to the appellate authority.
Page 34 is the acknowledgement. Page 34 is the acknowledgement of production.
Yes. That's there.
Rejection order is only page 16.
So 29 days delay.
Your Lordship. No, that 29 days is...
Yes. Outer limit, I will provide you. Yes.
That is condonable. I concede you.
Yes. Yes.
Send it.
Obliged.
Ajit dispose.
Yes, next.
Lordship, item number 10.
Item number? No, madam. What is your item? 10.
So item number 10, Your Lordship.
What is this?
Your Lordship, it's the matter between Mr. Speedy Agrawal versus the Commissioner of State GST Department, Cuttack.
That we find from the cost title. What is the matter about?
So, Your Lordship, we would like to withdraw the matter as a new cause of action as arose. So we would challenge that, and liberty may be granted to challenge that and withdraw this matter.
File your memo, madam, or withdrawal with liberty to file afresh.
No, by Your Lordship.
Yes.
File your memo, madam. You'll have to file.
The SOCO's notice has been challenged and subsequent.
I understand, sir. She has to file a memo. That's a procedural part here in this court. She has to. Where is your counterpart here? Who will file a memo? Madam?
Your Lordship, my senior was not able to appear because he had another hearing before the Honorable High Court of Chhattisgarh.
I understand, memo. There she has to. Somebody has to file a memo. Who has executed a Vogalatama? You have.
Lordship, the memo. No, Your Lordship, the local seniors have.
Where is the local senior? Somebody has to file. He is supposed to file the memo. Where is the local senior?
The memo has been already filed before the court.
No, there is no indication of the memo having filed. Is there?
I confirm that, Your Lordship, and then
yes.
I'll confirm that, and I'll.
Noting office note also.
Had you filed? There is no memo. Nothing. Sorry. Where is Mr. Swapnil Roy? N. Sharma? B. Aluwalia?
Swapnil Roy is local advocate.
Where is he?
He is regular practitioner here.
So let him. Yes, we are just making a pass. They're not today. Yes, next day. Yes.
Your Lordship, you're much obliged.
12. What is this?
It's covered under 74 B1.
Who is appearing for the other side? Notice. Yes. Then sub-item. What about sub-items?
Sub-item is also 73 would be.
Who is appearing? First sub-item and second sub-item?
Second set.
Yes. No, only to ensure that the other side is here.
Yes, I mean.
Item 23.
Yes.
180 mm.
Who is for the states? Yes. We have
2 meters, below, 2 meters.
yes.
Item 6 items.
Yes. What is that?
So this is a very, this raises a very peak within the
What pigment situation?
Just show cause notice number X gets issued to order in original gets passed on the basis of show cause notice number Y. I filed a rectification petition, not raising that issue, but insofar as other issues is concerned, rectification order comes, takes note of show cause notice number
Z.
X.
Oh, X. I said that.
Goes back to show cause notice number X, and in the garb of rectification passes a fresh order in original. Now that fresh order in original is barred by limitation as per section 7410. And it is, I have also checked, Willets, it is not covered under any of the notifications under section 168A of the GST Act. It is also, Willets, and also, Willets, there is a circular, which, Willets, after your lordship pointed out, I have also found out. There's a circular by the department, which has given a clarification of what is covered under the COVID exclusion order and what is not. And therefore, Willets, here is a case which not just is barred by limitation, Willets, but also, Willets, raises a question regarding the conduct, Willets.
Where is that judgment?
Yes. One judgment, Willets, is that Kasi.
Kasi is, I know.
Then there is a circular by the department.
You give me the Kasi judgment.
Yes.
That is 167. 2 CRPC.
Yes.
Kasi.
Kasi on 167. Right. That makes for a very interesting reading this fact of this case. Kasi Willets, para 17 to 19. Page 13. That's 28 to 20.
Yes.
This is the circular by the CIC department, which itself says what is the scope of the Supreme Court's the limitation, so moto limitation for that. And that circular, will see para 3 in the second page. Accordingly, legal opinion was solicited regarding applicability of the order of the Honorable Supreme Court to the limitation of timelines under GST law. The matter has been examined on the basis of the legal opinion received in the matter. The following is observed as per the legal opinion. Number 1, the extension granted by Honorable Supreme Court order applies only to quasi-judicial and judicial matters relating to petitions, applications, suits, appeals, all other proceedings. All other proceedings should be understood in the nature of the earlier used expressions, but can be quasi-judicial proceedings. Honorable Supreme Court has stepped into.
So what it says is that anybody who has a right to appeal, who has a right to move on a whatever the judicial sides, the period of limitations have been saved or extended by virtue of an order. But anything which is ordained in the statute to be completed within a particular time frame, and the authorities have not really completed it, it is kept outside the purview of that.
Roman 5 of that speech. The following actions, such as scrutiny of returns, issuance of summons, search, inquiry, investigation, and even consequent arrest in accordance with GST law, would not be covered by the judgment of the Supreme Court. This, is the quoting of the opinion. Then, para 4. It is hereby clarified that various actions comprised under GST can be broadly categorized as follows. A. Proceedings that need to be initiated or compliance that need to be done by taxpayers. Proceedings and compliances. These actions would continue to be governed only by the statutory mechanism and time limit provided or extension granted under statute itself. Various orders of Supreme Court would not apply the said proceedings, compliances on the part. Is the department's own circular that itself says that proceedings or compliances will not cover. Now, here, is a case, if your Lordship will see, kindly take page 17 of the brief. Page 17 is the show cause notice dated 29/9/2023 for the financial year 17-18. I'm sorry, July 2017, that's when the GST came in. July 2017 to March 2008. We'll see the amount involved at page 17. 17.
Yes.
We'll see the first paragraph. Short paid GST of 28.76 lakhs.
Yes.
Only on taxable supply made during 2017-18, July to March, relevant. That is the relevant period. Kindly take a note of the amount mentioned, 28.76 lakhs. And this also, if I may kindly show to your Lordships, the last page of this show cause notice at page 25, or second last page.
Yes, A and C.
Under sections, it is, if your Lordship will kindly know, under section 74 of CGST.
True.
Now, your Lordship will take the order in original at page 32. Now, let's see the order in original at page 32. Lordships, this is dated at page 32, dated 3/2/2025. Now, let's see the date. At the very top of the page. Order in original, number such and such, dated 3/2/2025. Plus, these dates are relevant, therefore, I just indicate it. Now, we'll see, take page 33. Reference. The show cause notice issued to Mr. Rajesh Kumar Kar having GST number such and such, under F number such and such, dated, we'll note the date of the show cause notice, 13/12/2023. The show cause notice that were issued to me was 29/9/2023. And your Lordship will see the amount involved, 38,71,000. Your Lordship saw that that amount was
28 lakhs something.
28 lakhs. And this is 38. Somebody else's show cause notice has been adopted in my order in origin. Now, we'll see the period.
Figures are also not tallying with your.
The period. We'll see the period in this order in original, July 2017 to March 2022. Your Lordship have seen it was from March 2018. Yeah. July 2017 to March 2022. Now, we'll see which is the show cause notice referred to in this order in original is further clear. It's not just the first para which has a typo. It is not a case of typo. It's a complete non-application of mine. Page 35 will see. Para 2.6. Again, the amount referred is under 2.6 Roman 1. 19.35, 19.35. That is that 38.7 lakhs, which is coming from this alien show cause notice.
And also the period.
Yes, period is for up to 2022.
Yes.
In the next, we'll see. Your Lordship, may kindly take page 47. Again, the same thing is repeated at para 10. Again, Your Lordship will see the period is July 2017 to March 2022.
Is consciously doing this.
Yes. It is.
In fact, there are two show cause notices, Melvin. There are two show cause notices, and that amount are different, and that heads are different, madam. And so far,
yes, the number is same or different?
Same SSC. Same SSC. Same SSC.
Two notices must have two assessment orders.
So cause
can't be merged.
Yes, my lord. But he has annexed only one assessment order, but not annexed order
two.
And the rectification.
You have two order in original. You have passed it to.
There must be means.
Must be that. Today is first time, my lord. But I'm apparent from this record, my lord.
You are assuming. You are assuming.
From the record,
You come with the instruction.
It is absolutely incorrect.
No, my lord.
Because
let him come.
Come with the instruction. Let him say that there are two separate orders.
My lord, it is demonstrated.
Tomorrow, come instruction.
Tomorrow, my lord.
No, tomorrow.
Next Thursday, my lord. Next Thursday.
Tomorrow.
May pay for next Thursday, my
No,
lord.
in the meantime, prejudice.
Because my lord, he has. I can come to. May I play, my lord? For
You just show us that there is a separate order.
My lord, may
If they are suppressed, we know how to deal with
the lordship will
litigant who has closed the court by suppressing. Come tomorrow. Give it.
It is from Rahul Kela, may.
Whatever, over the telephone, you know it very well.
Scanned document we can. So they are uploading all. You can access their site also.
I can.
Yes, we can send you.
My lord,
It is all uploaded, sir. Nowadays, all orders are uploaded.
because on the record, it is
Come. You will give me
You have seen notices are being uploaded and they are not accessible.
I can show it right now.
Please, sir. He has.
tomorrow.
Yes, sir.
Tomorrow.
You can play, my lord, on Monday or at least.
Tomorrow is immediately after that.
Yes.
May I be pardoned, Lordship? Item number 9, Your Lordship.
Yes.
This is regarding service tax matter, Your Lordship, 73(4)B, Your Lordship.
Yeah. Which one are the yes. 73(4)B?
Yes, Your Lordship.
Yes. Okay. Any other?
No, Your Lordship. Obliged, Lordship.
Any who is present, any other matter which you wanted? No.
Madam, item 29.
Which one?
Item 29.
29.
Lord, item number 29, your Lordship has, on the last occasion, your Lordship has directed to take instruction. Your Lordship, the instruction we have called for the confirmation from the concerned executive engineer, and we have not received the same, your Lordship. So, your Lordship, I request 2 weeks time may be granted for confirmation.
Already under the RTI, they have given the information.
Your Lordship, only for confirmation.
Information they will get from again. Under the RTI Act, my lord, I have remembered that.
He is seeking for one. One occasion.
Yes.
My lord.
Item 43.
1 week.
Sit down.
All is
Next.
yes.
Item 43.
The Lordship, 1 week after your Lordship, because we have.
Yes, next week it will be there. Yes, only 1 week.
43. That is 28 days.
What?
That is 28 days.
40?
28 days.
Have you served the copy?
Yes, ma'am. That is I heard. And also,
Have you served?
I have ordered some
Mr. Tripathi.
State is here, Pati.
Have you
Yes, sir.
received the copy?
Let it allocate to Mr. Roth and there are let it come next week.
Sir, oh,
The next week.
He's not here.
Item number 26 will be taken up
Next.
near the
Mr.
Next week it
Counsel,
will come.
Mr. Counsel, some private parties are also there. Then you have to say
There is no notice.
notice,
First issue notice.
notice in IA to private opposite parties.
3 weeks. 3 weeks. Next one.
Yellow that is good.
Item number 26 will it's an income tax matter. You will be taken up next week.
We are not taking up, today is an exception. We do not want any matter to be taken up ex parte. That's why we wanted the other side to be here. And that's why we are not going serially. We are inviting everybody to come and argue. Where both sides are here. All those matters will spill over to the next week, don't you? Is any other matter?
Item 32, Your Lordships.
Yes.
Your Lordships was categorically, my lord, the state was instructed to portal to unblock my portal, my lord, because he has, after a request for withdrawal of the bid, portal was blocked. Thereafter, on merit, it was disqualified. my lord.
Yes. Who is appearing? In 32?
My land, Mr. Tripathi was directed my lord, last order, so that
Mr. Prabodh, she is
Yes,
not,
sir.
she is not there today.
Mr. Tripathi.
Mr. Das is
No, Mr. Tripathi was last order, so that let's.
Anyhow, we understood. Yes. Next. Any other matter?
Okay.